Welcome to Under Review. I'm your host, Alex Su. And before I get into it, I want to introduce myself a bit. I started out my career practicing law, but then somewhere along the way, ended up making funny videos on the internet. Today, I have a really interesting job. I'm the Chief Revenue Officer of Latitude Legal. But throughout my entire journey, I've always been interested by one thing: how the legal profession is changing. And that brings me to this show. Under Review is produced by Stanford Law and PLI. On the one hand, you have deep academic insights, and on the other, you have real-world relevance. The way we're organizing the show is this. First, we're going to cover a story that's big in the legal world. Then, we'll share an academic insight that has real-world relevance. Third, we'll interview a changemaker, someone who's shaking things up in the legal industry. Our hope is that the show is informative, interesting, and practical to your day-to-day. Thank you for tuning in. All right, let's kick things off with a story that's rocking the foundation of business law, and it's all happening in Delaware. Now, if you're not steeped in corporate practice, you might be wondering, why does Delaware matter so much? Well, over 60% of Fortune 500 companies are incorporated there. Delaware long has been the gold standard for corporate governance, with courts, statutes, and a whole legal culture built around business law. It's basically the legal home base for capitalism. But that dominance has been tested lately. One of the biggest sparks is a string of high-profile disputes involving none other than Elon Musk, especially a massive compensation package for Elon at Tesla that was overturned by a Delaware judge. That ruling drew national headlines and even political attention. And while all of this is happening, other states like Texas and Nevada are circling. They're pitching themselves as more business-friendly, more predictable, trying to peel companies away from Delaware. So where does that leave lawyers, especially those advising boards, startups, or investors? To dig into that, I sat down with two of the smartest voices in corporate law, Stanford's Robert Bartlett and Columbia's Eric Talley. We talked about what these changes mean for practitioners, for corporate clients, and even for legal education. Here's that conversation. Professor Bobby Bartlett and Professor Eric Talley, welcome to Under Review. Let's get right into it. Professor Bartlett, Delaware corporate law is a staple in nearly every corporations class. The majority of Fortune 500 companies and most private startups choose to incorporate there. Can you share with us why Delaware has such a dominant position?
Yeah, Alex, thanks. And thanks for hosting us here. So there's a couple of reasons I think that really come to mind. So one of them is that Delaware is a really small state. And so decades ago, it had made a decision that it was going to try to compete for business and corporations as a source of tax revenue. And it was in some sense wildly successful in doing that, in part because of the legislation that it developed with respect to its corporate law was carefully tailored to the concerns of those that have the ability to make incorporation decisions, and was also sensitive to protecting investors. And so you had basically, both investors and management pulling in the same direction in terms of wanting to incorporate in Delaware. And then you add to that the fact that the Delaware Chancery Court, where business disputes pertaining to the internal affairs of a corporation are heard, also invested in quality, as it were. And so you have a perception of high quality corporate law as well as a high quality judiciary to resolve disputes involving disputes between corporate investors and management. And then separately, you also started to have network effects. So the more people who perceived Delaware law to be of a high quality, the more it was expected that if I'm a high quality company, I'm going to want to incorporate in Delaware.
Professor Talley, Delaware's dominance in corporate law is suddenly facing real challenges, and Elon Musk is right in the middle of it. Can you walk us through what happened and why this moment matters?
Yeah, I'd be happy to do so. And thanks again for having me on the show as well. So Mr. Musk plays clearly a large role in this entire process, but not the only role. One of the things that's been happening in Delaware over the last 20 years is sort of an increasing migration to various types of ownership structures of publicly traded companies and certainly privately held companies in which, one or two shareholders plays a real outsized role. And Mr. Musk is clearly the poster child for that. In the last 6 or 7 years, he's had significant run-ins with the Delaware courts as well as the federal courts. And many of these run-ins have stemmed from his being not only an iconic entrepreneur and figure, but also sort of doing double, triple, quadruple, quintuple duty as the manager of these large companies, many of which, at least a couple of years ago, were all Delaware companies. So, you go back a few years, there was the acquisition of Solar City, which was another Musk-affiliated company that was on, by some people's accounts, on death's door, and it was kind of salvaged by Tesla. That gave rise to all kinds of litigation about whether that was a conflicted controller transaction. There was the, kind of the teasing tweet about funding secured to take Tesla private at $420, which is a famous and favorite number of Mr. Musk's. That ended up getting him into some, SEC type hot water and some securities fraud lawsuits. And then the famous or infamous acquisition of Twitter that Mr. Musk, with great fanfare announced in the spring of 2022, spent most of the summer of 2022 trying to get out of it, and then got sued by Twitter to close the deal. I think most people thought he was probably destined to lose, maybe for the first time in one of these big cases in that situation, and he decided to close the deal anyway. So there's this backstory. Mr. Musk has been playing an increasing role in a lot of these important cases that have been coming forward. And all along, there had been another case that had been sitting there since 2018, which is the case that was challenging his compensation package that was awarded him back in 2018 by Tesla. This was a package that was heavily skewed towards incentives and making various types of benchmarks. And if he ran the table on all these benchmarks, which Tesla eventually did, it would entitle him to a compensation package in an amount of around $55 billion. And in January 2024, after two judges and a long time of litigation, Chancellor McCormick in Delaware invalidated that pay package, basically holding that, and we can get into the specifics if you want, but holding that Mr. Musk was a controller of Tesla. His pay package was therefore a conflicted transaction. It therefore triggered Delaware's longest standing common law sort of edge of caution against controller conflicts, the so-called entire fairness doctrine. And it just wasn't appropriately defended in her view, and she invalidated the entire compensation amount. Now, people can pick nits, and Professor Bartlett and I have done so ourselves about, the various junctures of the reasoning of that opinion, but it certainly did not land well with Elon Musk. Within 24 hours, he was dropping tweets on his new platform saying, never incorporate your business in Delaware. He's followed up with many other vitriolic tweets, basically hating on Delaware for a variety of reasons, but most people believe it's this. And in fact, other controlled companies that are sort of within the Elon Musk sphere of influence decided with great fanfare to leave Delaware and go somewhere else, usually to Nevada, but Texas is another place. And in fact, Musk famously took Tesla and Twitter out of Delaware.
So, Professor Talley, so what's Delaware done in response to all of that pushback?
Well, as I noted, there was a new governor, in the beginning of 2025. But the process started even before that. If you go back to 2024, very shortly after this Musk opinion came down, there was a second opinion that came down involving a guy by the name of Ken Moelis and his financial company, in which he was a controller, but he had reserved all kinds of rights contractually for himself to basically, sort of elbow into what the board was doing, its composition, having all kinds of veto rights over various types of transactions that traditionally under Delaware law are left up to the board of directors. This was challenged as being inconsistent with Delaware law. And a different judge, Vice Chancellor Laster, actually held many of those contractual provisions to be invalid because they weren't in the charter. This caused itself a big movement in 2024 to essentially elevate the status of shareholder agreements to be basically equal to, or in some cases, even more important than the corporate charter of companies. And so there was a big amendment in August of 2024 that basically did that. And most people understood that as being an overture to make Delaware more friendly to controllers. All they had to do was work out one of these contractual provisions. Well, the ink was hardly dry on that when in 2025, the new governor of Delaware evidently voiced some concern that companies were still going to be leaving Delaware, and a brand new proposal got put forward. It got put forward in a very peculiar way. It didn't go through the usual channels that corporate law amendments go through in Delaware, a so-called Delaware Judicial Council that is made up of sort of representative attorneys from both the plaintiff and defense bar. This came straight from a senator in the Delaware Senate, and a team of people that were actually the attorneys for Meta, which was one of the companies that was threatening to leave. And these amendments, basically got fast-tracked way ahead of where they usually, corporate law amendments usually occur in the mid to late summer, and were finalized basically in March and made huge, I think in many cases, groundbreaking amendments and changes to two pretty bedrock areas of the Delaware Code, Section 144 and Section 220. And this was all within something known as Senate Bill 21. So a lot of people talk about these changes and kind of clump them together as part of SB 21.
So, Professor Bartlett, now that Senate Bill 21 has been signed into law, how has Delaware corporate law changed?
Yeah, at a high level, as Eric mentioned, there's really two substantive areas where the change occurred. So the first one is with respect to Rule 144, which historically was about how do you assure that a transaction involving an officer or a director in the corporation isn't void by virtue of the conflict of interest. 144 has been amended by virtue of SB 21 to effectively create a safe harbor for conflicted transactions involving both corporations and their directors and officers, but also with respect to corporations and controllers. And so it picks up on this theme that Eric was articulating, that a lot of the concern and the momentum behind these legislative amendments were really about trying to make Delaware hospitable to controlled companies. And it's useful probably to back up a little bit and think about why controllers were so concerned about where Delaware had been drifting over the last several years. And it's in part because the definition of who is a controlling stockholder has gone from a fairly bright line test that if you hold 50% or more of the voting power, you're a controller, and therefore you owe fiduciary duties to minority stockholders, to being more of a transactional test that looks at, do you have the power to either influence the corporations generally, or do you have the power over a particular transaction? So it could be by virtue of shareholdings, but also could be by virtue of managerial authority, for instance. And so the dividing line between who is a controller and who isn't has gotten a lot more difficult to surmise. Secondly, there was also always this understanding that you could get a lot of comfort with respect to trying to have a contract approved by disinterested directors. But then the question of who's a disinterested director has also started to morph over the years, so that if you had an interest in the transaction, you were certainly not a disinterested director. But if it was a controlling stockholder that was a party to the transaction, and you were somehow beholden to that controlling stockholder, and by beholden, it could be any type of financial or non-contractual relationships, such as your kids play soccer together, for instance, that can make you interested for purposes of that transaction and not a disinterested stockholder. So it became really, really hard to actually find a way to preserve business judgment review of transactions involving a controller, except if you went through what is known as this two-part cleansing process, where you have from the start a commitment to have the transaction approved by a disinterested board of directors or committee, and then approved by a majority of minority or the majority of disinterested stockholders as well. So that's this MFW two-part cleansing stage. So that was sort of that was where the table was set when SB 21 was first proposed, and the idea was we're going to basically backpedal on both of these fronts. And so first of all, we're going to hardwire a controller to be you hold 50% of the voting power, or you have a third of the voting power and you have a managerial authority such that you can act as if you are a controlling stockholder in the conventional sense. And then secondly, we also are going to define who is disinterested based on financial interest in the transaction. And so therefore, it should be easier to define yourself as either a controller or not a controller, or a disinterested stockholder, a disinterested director, or an interested director. And then lastly, what we do is we then reform the cleansing process under 144 so that if you are looking at a contract involving an officer and a director in the company, such as, say, an employment contract, then you can get automatic cleansing through simply a vote of majority of disinterested directors present at the meeting. And then if it's a transaction involving a controlling stockholder and the company, except for transactions that involve what are called going private transactions that are regulated by Section 13 of the Exchange Act. So as long as you're not taking a company private from, say, NASDAQ into private ownership, if it's just a controlling stockholder transaction, such as approving the compensation of a controlling stockholder who holds, say, more than 50% of the company's majority voting power, then you can cleanse that transaction against either equitable or monetary challenges by either having a majority of the disinterested directors approve it, or by having a majority of the disinterested shareholders approve the transaction. And so now you have instead of having mandatory two-part cleansing, from the start, now you have the choice of either cleansing the transaction through a vote of disinterested directors or a vote of disinterested stockholders. So that's with respect to concerns on who's a controller, how do you give assurances that a controlling stockholder transaction will be validated. And then there's a separate bucket of reforms that related to Section 220 shareholder, basically books and records requests. And there, SB 21 fairly dramatically cut back on the scope of what you can ask in a books and records request. And I guess I would say among sort of the big changes there are that you can only initially have your books and records requests relate to sort of formal corporate records, minutes, for instance. No longer can you then ask for all communications such as emails or other written correspondence between directors and officers. And then secondly, there's a 3-year look back period. So you can't ask for books and records that exceed the prior 3 years.
Professor Bartlett, as Professor Talley mentioned, other states are reacting to this, right? Texas and Nevada are making moves to attract corporations away from Delaware. What's the pitch they're making, and are we seeing companies actually make the jump?
Yeah, the pitch they're making is largely one of predictability, particularly if you're a controller, which is exactly what sort of got Delaware into this situation, is that there was concerns that Delaware became less predictable in terms of being able to confidently contract with a controlling stockholder, or even someone who historically was not a controlling stockholder, but may be a controlling stockholder if you get before a chancery court and the facts somehow suggest that they're acting as if they are a controlling stockholder in the conventional sense. And so predictability, I think, is really what these states are offering, and I think that's what's driving a lot of these concerns. To date, as Eric said, there haven't been a lot of companies that have made the move. The ones that have done so have generally been companies that have really large controller positions. And so you think, take a company like Dropbox. Andrew Houston has over 80% of the voting power because of the dual class structure. Trade Desk, Jeff Green has almost 50% of the voting power. Affirm, Max Levchin has 44% of the voting power. So these are companies that they really are companies that are likely to be deemed controller under the conventional approach, and probably even under the new approach to a controlling stockholder. And if going to Nevada, as was the case with Dropbox, Trade Desk, and Affirm, they're going to be able to have a lot more predictability. Now that comes at a cost, as Eric said, which is that you have a whole class of shareholders who largely have to hope that the controlling stockholder is going to be acting in the best interest of the corporation as a whole, and not just their own personal interests, which is why historically we have worried about controlling stockholders as owing some special duties that aren't owed by non-controlling stockholders. I do want to actually also note that I do think I'm going to align myself with a position that may differ from Eric's here, but I am sympathetic to the need for predictability and the unpredictable nature of being a significant stockholder, particularly in a private venture-backed startup over the last several years. And so I do think that to a certain extent, some type of course correction within the Delaware corporate law, within the case law, made a lot of sense, at least in terms of trying to find predictability. And I think about a company that has 3 venture-backed investors that together hold over 80% of the voting power of the company by virtue of their convertible preferred stock. I think it had gotten to the point where it was really hard to approach any type of insider transaction, like an insider financing, for instance, without just assuming entire fairness was going to apply. And I think that whether or not you necessarily have to take that transaction through the MFW two-step approach, that could impose a lot of costs relative to a regime where you had plausibly independent directors that were able to sort of take the banner of the corporation as a whole and really evaluate and negotiate with the venture capital and investors. So I do think that that I'm somewhat sympathetic to what the goal was in terms of SB 21 and trying to create predictability. But I absolutely agree with Eric that the rule that the ultimate statute that we got is filled with all sorts of low-hanging fruit to contest, whether this transaction really was compliant with the cleansing regime set forth under SB 21. And just as a concrete example of that, there was one modification, or there was a series of modifications made in early March to the initial bill of SB 21, and one of them was to say that the disinterested directors approving a transaction do so in good faith and without gross negligence. And so we can, I think, confidently assume that there's going to be some litigation about whether or not this purportedly cleansing exercise by the disinterested directors of a board of a controlling transaction or of a officer director transaction was in fact fully compliant with the new 144. Because there's another provision of 144 which says, if you don't fully comply with the cleansing process, then basically all bets are off, and you can continue to challenge the transaction under the standard regime.
That's all the time we have for questions today. I just wanted to thank Professors Talley and Bartlett. Thank you so much for sharing your insights today with us, and we really appreciate your time. All right, now let's shift gears from the boardroom to the classroom. For our second segment, we're digging into a fascinating research paper called "Can AI Hold Office Hours?" It's co-authored by Stanford Law professor Lisa Larrimore Ouellette, and it asks a very timely question. Can large language models like ChatGPT actually help law students learn, or even take over some of the work professors and teaching assistants do during office hours? To walk through the findings and what they mean, we're turning things over to Stanford Law's Associate Dean and our show's producer, Adam Sterling, who sat down with Professor Ouellette to talk about the research, the results, and where we go from there. Here's that conversation.
Professor Ouellette, welcome to Under Review.
Thanks for having me.
So let's jump in. Can you walk us through the basic setup of the study? How did you train these AI models? What did you ask them to do? And how did you evaluate their responses?
Yes, we weren't training them in a technical sense. We were prompting the models. So we uploaded the text of our casebook, which is about 250,000 words, and then asked the different models to act as a tutor in these classes and answer questions based on the casebook materials. And then we experimented with different prompts with a set of holdout questions different from our main sample to see what kind of prompt led to the most accurate answers. Interestingly, we found that when we asked them to be very concise, they often were less likely to give an accurate answer. And when we asked them to think through your answer step by step, they were more likely to. So we tried to tweak the prompt to figure out how we were getting the best answers. And then we came up with a large set of questions. There were 185 questions. About a third of them were like actual real questions students had emailed us over the years. A third were just questions asked in the casebook itself to prompt students to think about the materials. And a third were questions we came up with based on things students had asked us during class or in office hours. And we fed all these questions into the 3 different models and then took the output and evaluated that so every output was independently graded by 2 of the 4 co-authors, and then we resolved any discrepancies and used that to get some assessment of how accurately they could answer these questions that students had.
I love it. So it sounds like you basically asked these large language models to read your patent law textbook, and then you gave it a little bit of guidance on how to sort of respond to questions. And then you took questions that you've received from students over the years and some other ones and said, okay, now that you've read this patent law textbook, answer these questions.
Yeah, exactly.
Before doing this research, what did you expect the results would be?
Well, we thought there'd be a lot of variation based on the type of question. So that, if it's a question where the answer is basically in the casebook, where you can answer it basically just copy and paste something from the casebook, including ones where the casebook asks a question and then answers it directly, we thought AI would be very good at that kind of pattern recognition, and that would struggle more with questions that require more synthesis of material or drawing inferences from the text. And we also thought that Notebook LM would perform really well because it was designed for specifically this kind of task of answering questions about a constrained text. And Google advertised it as reducing the rate of hallucinations because it's grounding its answers in the text in that way.
So what were the results? So you had these assumptions. Were they proven accurate? And how do the model's results compare to one another?
Yeah, so surprisingly, Notebook LM performed the worst of the 3 models. So we graded all of the answers on a 3-level scale where we said the answer was good, meaning basically all the substantive information that we would expect the answer to have. That was the best. The worst were unacceptable. So it was actively harmful for learning, misstating the law in a way that we thought would be misleading or confusing for students. And then the middle ground of acceptable, where maybe it doesn't fully answer the question, but has the most minor errors, things we didn't think would be actively harmful for learning. And the rate of unacceptable answers. So for Notebook LM, it was 31% of the answers overall had that lowest grade. For GPT, it was 26%. For Claude, it was 14%. So Claude was the clear winner among the models, but still had a large number of answers that were unacceptable in the sense that we thought harmful for students who are trying to learn patent law from them. The highest grades, again, Notebook LM performed the worst there. So the ones getting this good score, Notebook LM had 37%, GPT had 49%, and Claude had 56%. So I think whether you view this as a success or not depends on what your priors are.
Totally.
On the one hand, it's amazing that that many of the answers are actually it's able to. All of the models are able to produce answers that have the correct substantive content. And if you told me that 5 years ago, it would have seemed like science fiction.
Totally.
But on the other hand, I think the rate of unacceptable answers and things that are going to be confusing for students who are trying to use this in the same way they ask questions to professors during office hours makes me think that these aren't ready to be rolled out by students without some kind of supervision or something like that.
Fascinating. So the conclusion of the paper was AI is not ready to start holding office hours. Can you unpack that further? I think we have a sense for why, but maybe in doing that, was there anything that sort of impressed you about it?
Yeah, I mean, they had a lot of good answers in ways that I wouldn't have expected, even a year ago. And I think that is cool and exciting. And I'm continue to be excited about the thinking about how to incorporate AI into pedagogy and whether there will be ways in which it can be useful. But I think before this project, I was more optimistic that I would be able to recommend these tools to my students and say, here's another learning resource you can use and use this as a supplement to office hours. And now instead, at the beginning of when I was teaching patent law this quarter, I showed my students the results from this paper.
Love it.
And said, be really careful and encourage them, if you have a question, email me. I am not overwhelmed by emails. One of the great things about teaching at Stanford is that we have such small classes and can get to know our students. And so I'm able to handle all of their questions, and I would much rather they come to me with them than asking these AI tools and having the risk of a misleading answer. Well,
we know you'll be following this closely, so we'd love to check back in with you soon and just appreciate you spending time with Under Review.
Sure. Thanks for having me.
To close out our first episode, we're bringing you something a little different. Each episode, we'll sit down with someone we're calling a change maker, a legal professional who's taken bold steps, broken new ground, or carved out a path that's redefining what a legal career can look like. Today's guest is a perfect example of that. Kristin Sverchek started her legal career during the Great Recession. Not exactly an easy time to be a young lawyer, but just a few years later, she made a leap that would change everything. She left private practice to become the first in-house lawyer at a startup called Zimride. You might know it better by the name it eventually took on, Lyft. From there, Kristin didn't just rise through the legal ranks. She became general counsel, then moved on to business leadership, and ultimately served as the president of Lyft. Her story is a fascinating look at how lawyers can evolve into broader leadership roles and how legal skills translate to the boardroom. We talked about a lot of different topics, including her career journey, managing risk, how she transitioned from legal to beyond. It was a fantastic conversation, and I hope you enjoy it as much as I did. Kristin, so excited to have you here. Walk me through your journey at Lyft as the first lawyer and growing that legal team.
Yeah. So, day one on the job, it's like me and that's the team. Mm-hmm. And even in that first day, we were at the time only operating in San Francisco, didn't have any regulatory framework at that point. And so the very first day, the co-founder said to me, hey, we're going to meet with a commissioner at the California Public Utilities Commission, like, come with us. And I was sort of like, okay, you can't say no, it's your job, but I didn't know what I was doing. But so the learning curve was super steep, and not just from the substantive law, but also the difference between being in-house counsel and outside counsel, which I don't think I properly understood until the moment that I was in-house counsel. And so, that first year it was sort of me on my own figuring out how to navigate it. As the years went by, it was slowly but surely adding 1, 2, 3 people to the team. After 3 to 4 years on the job, I finally started to hire a little bit at scale, which thankfully, because this was at the time that we were expanding super rapidly, we were starting to see quite a bit of litigation. And ultimately, that team, I think today it's probably 150 people.
Wow.
At the time, when I started, it was just me. And for many years thereafter, it was single digit number of people. And so it was growing the team. And then it was dealing with all of the things you have to deal with as a manager. For example, making sure your team members are appropriately compensated, because we didn't have a framework for how to compensate lawyers, because that is not what an early stage startup is thinking about. And then, successive rounds of financing, and then obviously ultimately the initial public offering. And I had worked in the private financing practice. I really wasn't a capital markets attorney. And so, having to dip in and learn all of these areas of law and expand my skill set. So those years were just growth in every way possible, horizontally, vertically, et cetera. And so let's see, I was in the general counsel role from 2012 to 2021. So 9 years of that, which I guess it's helpful to mention too, because, sometimes I think people think of career growth as you get a new title, but I had the same title for 9 years, but it never felt boring or a staid job, because every year brought so many different challenges relative to the prior year.
I think it has a lot to do with the growth mindset.
Yeah.
Going back to what you said earlier, before you even took the job, you were asking questions, trying to learn. Yeah. And I got to imagine that served you well over the years. And I do want to fast forward to 2021, because I remember seeing an article about you, maybe in the American Lawyer, about you taking on this more encompassing role beyond just legal. And that's actually a big trend these days, where GCs are taking on what we're calling GC plus, overseeing sometimes HR, policy, or other functions.
Yeah.
And I remember seeing that article, and you were taking over a wide range of tasks. Talk me through how that came about, because I think a lot of people who are leading legal teams would love to hear about how that came about.
Yeah. It's funny because it wasn't self-initiated. And I share that because I don't know if I think I probably would have ultimately gotten there on my own. I still wasn't bored yet at 9 years. And, already at that point, people were asking me well, what are you going to do next? What are you going to do next? And I felt gosh, like I'm learning and growing all the time here. So I can't even think about what's next. But ultimately what happened is a board member came to me and said, you've been here such a long time. You're such a trusted advisor to the co-founders. You've proven your chops as, just as a leader generally, not sort of just a lawyer. So like, you know how to hire and retain talent. You know how to have an engaged workforce. You know how to demand, a high standard of quality. And those are skills that are translatable to other teams. Like that's not just for legal. And so like, I think you should talk to the co-founders about getting a bigger scope, but like, I'm not going to do that for you. So if you want it, you need to do it for yourself. And it got that sort of bug in my ear that I just, I couldn't stop thinking about, okay, like this is right. And it was a little bit scary because I felt like I knew what I was doing as a general counsel by that point. I'd had the years of imposter syndrome and had kind of finally moved past that. And I was like, okay, I'm good. But it's to the growth mindset point, it's important to never let yourself get really too comfortable, right? And so I went to the co-founders and I sort of pitched them on this idea that I would take over, call it a lot of the like back office type work of the company. And, it would allow Logan, our CEO, to focus on tech and finance. It would allow John, our co-founder and president, to focus on all of the external communications type stuff, comms, marketing, investor relations. And I could take on all of the stuff that went into like the day-to-day running of the business. So it was legal and people and policy, business development, the chief information officer, real estate, some other things that actually like grew and changed through the years and things went in and out. But it was sort of like, I can step up and help you do anything you need me to do because I know how to run a team. And to my, I think like somewhat surprised, like they just immediately said yes. I was prepared. I really had prepared myself with a lot of advocacy points and I didn't even need to use those.
It's always the best when you don't have to pitch them and they just say yes.
Yeah, I think, but I was so ready for it, that like, I think all of those points are still like filed away somewhere unused, in my email. Yeah.
I imagine that, now that you've gone from GC to president of business affairs and then president of the company, you've had a lot of interactions with the board and you can see a lot of things, see the field differently than that first year when you were the first lawyer. I want to shift quickly on the topic to what you see that's happening in the world that you find interesting or exciting. And I know that you've taken some time off. Tell me about what areas you find interesting in the world today.
Yeah, I mean, look, like it's an amazing moment to be in tech. And part of like when I left Lyft, I was pretty certain that I was going to stay in tech, writ large, but, still wanted to take a pause and just kind of like reassess. And, as I've watched the emergence of generative AI and just the scale at which that's been developing, or I should say not scale, rapidity, but also scale of development, like it's been so exciting to feel that we are really on the cusp of this kind of revolution of the way that we all work. Obviously, that's going to be hugely impactful for lawyers, and I think already is starting to be. So I think that's super exciting. But there are so many other new and disruptive technologies kind of at the forefront. I just joined the advisory board of this company, Deep Fission, that puts nuclear reactors a mile underground to help develop, allow for deployment of clean energy. And that's something I'm personally really excited about because nuclear has been a technology that, sort of had its heyday and then I think had a bad name, but I think now as people are coming around realizing like, oh, actually it's a very safe, affordable, and meaningful way to provide clean energy that is not, limited, such as like wind energy, solar energy, et cetera. So like that's something I'm super excited about. And, by the way, that's not like an area that I have particular expertise in, but what I do know is how you navigate as a business when you're at the forefront of what law and policy means. So I'm super excited to help that company. I also, of the other folks I've gotten to talk to, other cool technologies, it's like, it's hard for me to even think of an example because there's so much happening right now.
To me, it sounds like as just an outsider hearing about all this, you went from supporting startups to kind of inhabiting this area
Yeah.
where you have regulations and laws that have not updated to meet
Exactly.
new technologies or new innovation. And it seems to be closer to what your specialty is now. And I got to imagine that's why Deep Vision sought you out.
Yeah, absolutely. I think it was both that like understanding of how to operate at the forefront of law and policy, but also just the understanding that like scaling a company from, where the Series B, 30 people, up through, years post public offering, like somebody who's been on that trajectory, like that is a relatively unique skill set because you have a lot of people who plug in the earlier days or plug in the later days. And some people that is, it's very much their identity, right? Like they're an early stage entrepreneur or they are like a public company person. And so I think the thing that I feel fortunate about in terms of just like my staying power at Lyft was having gotten to see like all of those things and experience the ups and downs over those years.
Yeah. And that's a valuable skill set, it seems like, everywhere.
Yeah, I think so. Yeah.
And I know that many younger lawyers earlier on in their career, maybe they're at a law firm, maybe they're in-house, they may seek to replicate your path. And so what advice would you give those folks about how to navigate the path forward?
Yeah. A lot of folks, over the years have come to me saying like, hey, I'm a first-year associate at X law firm and I want to be a GC like you one day. And how do I get there? And like my first question is always, why do you want to be a GC? And I think, for some folks, it's like, okay, I know that's a good title. And so like, I want to achieve the title because lawyers, sort of stereotypically very ambitious, right? And driven individuals. But like the job of a GC is not for everybody. And it's, and there are many lawyers who are better suited to law firm practice, as an example. But for the folks who are like, well, I really like being integrated into the business and I'm okay with having only one client and I'm okay with all of the demands on the time. I also think there used to be like this notion that somehow GC was better for work-life balance. Like it's not. But that's okay. Because in my case, it felt like if I'm going to make one investment with my time, I want it to be something that I'm really deep in versus many, many different clients that I'm spending a little bit of time with. And so, for those people who are interested, so first I really like pressure test them on the why behind their interest. But, assuming that they sort of have that fortitude, like the thing that I always encourage people to do is take risks in their career and jump into different things that interest them. So like the sooner you can gain in-house experience, I think the better. Like I think a little bit of foundational law firm experience is really valuable, truly. And sometimes this is an unpopular opinion because people like don't want to start in big law anymore. But big law does train you really well, both substantively and in terms of, I think, work ethic and quality. And you could always see that in the big law trained lawyers. And so I actually am a fan of that as a foundation, even for folks who want to go in-house. But for those folks, like I would say, make sure you're taking the time to add things to your tool belt. So like if you can get an in-house job that is something different than what you did at the law firm, like that's great because you're a better, more well-rounded attorney. And that allows for progression, sort of within an in-house position. I also think like for folks who want to be a GC, they need to really think about what kind of business is interesting to them. Like, is it consumer facing? Is it B2B? And in my case, I loved consumer facing. And I don't know that I'll only have consumer facing roles, by the way, but I loved it because Lyft was a recognizable brand. I loved that the legal team was at the forefront of the company because of legal and regulatory issues and like the extent to which that was existential to the business. And so for me, it was really fulfilling. But for another person, like my job would have been probably like horribly chaotic. So it wasn't a job for everybody.
What about for folks who are maybe in the GC seat, maybe chief legal officers who want to expand their scope? what advice would you give them to start building the same level of credibility and trust with all the stakeholders in their organization, just as you did?
Yeah. I mean, like one of the things, so building credibility and trust takes time. And so, I have, it's funny because I've also had those same conversations with people who like joined the company as GC yesterday. And then today they're like, I want to take on more. And it's like, well, your leadership team doesn't even know you or what you can do. And so, in my case, I think it's easy for folks to be like, oh, you were GC and then you were president of business affairs and then you were president. But like that was a 12-year journey. It didn't happen overnight. And the GC role was 9 of those 12 years. And so, so the first thing I would say is like, take the time to be really good at being a GC. And that's not just like the legal work, but it's also the team management. It's also the peer relationship development. It's also the trust building. And if you can navigate team management and build trust with peers, those are skills that you can really implement into other skill sets as far as leadership internally at a company. But like, if you can't prove that you can do those things, like your leader shouldn't trust you with more, right? So I think patience is something that is often overlooked, but it's also leaning into all the things I mentioned.
I think the big theme that I'm hearing from everything you're saying is to make sure you're doing a good job at the job you have today.
Yes.
And in this world right now where there's so much chaos and uncertainty, what advice do you have for lawyers and business folks, everyone, as we kind of navigate this uncertain environment?
Yeah, it is a hard time. I mean, that is for sure. And I will share, like at Lyft, interestingly, like most of the years through public offering were fairly up and to the right in terms of like good times, ability to raise capital, ability to grow the team, ability to spend money on marketing, like all of these things. And when we went public in March of 2019, like we never would have imagined a year later in March of 2020 that all of a sudden the world would shut down and no one would want to get in a rideshare anymore. And so, the COVID and post-COVID years were really tough in that we had to do, multiple successive rounds of layoffs, other OpEx budget cuts, compensation reductions, all these things. And I think it's, again, easy to look at just if you look at the titles on my LinkedIn, you'd be like, oh, up and to the right. But there were so many hard times in there, days, weeks, months, 6 months that were really difficult and a slog. But that they would correct. And then you'd have, an injection of energy from some exciting new product launch or something like that. And the thing that I tried to keep in mind for myself, which I really tried to talk to my team about, was the importance of learning from those hard times. Because like, if all you know is good times as a business professional, you are not a well-rounded business professional at all. Like, you know a little bit and you know how to operate on easy mode. But to learn all the skills that it took, for example, to do a large-scale reduction in force, like, really not fun, tested my empathy, tested my resilience, tested all of that. But like after having done it once, I felt like, okay, I understand now how to do this. And this is something that businesses need to be able to do. And so this is like a skill set that I will carry forward in my own tool belt for future jobs. So yeah, I tried to find the silver lining of the bad times.
I could go on and have this conversation. I'm getting so much out of it, but we are running out of time. So before we wrap up, Kristin, is there any message you want to send out to the audience, whether it's advice, insights, thoughts about anything?
I actually would call back to what I just said, which is that the good times and the bad, there's something to be learned from both of those. And applying that growth mindset to your career, you look to find the learnings in everything that you do, even when it's unpleasant in the moment. I've almost always looked back on those times and thought, gosh, that's when I had the most learning. And and really felt grateful for it, even though it wasn't fun. So I would say, even in these chaotic times, think about what you can get from what you're doing.
That's really well said. Thank you so much for your time today, Kristin. I'm sure we'll see you around soon, but really appreciate you coming by the studio to speak with me today.
Thank you so much for having me.
That's a wrap on our very first episode of Under Review. Huge thanks to our incredible guests, Professors Robert Bartlett, Eric Talley, and Lisa Larrimore Ouellette, and of course, Kristin Sverchek, for sharing their time, insights, and stories. We're just getting started here. Every episode will bring you more conversations that connect the dots between legal practice, research, and leadership. If you like what you heard, do us a favor. Share the episode, leave a review, and tell a friend or colleague. You can watch the full video and earn CLE credit over on the PLI platform. The audio version is live on all the major podcast apps, and we'll be posting highlights on social, so follow along wherever you like to get your legal content. And most importantly, I believe the show is a two-way conversation, and I'd love to hear from you. So what stood out to you? What should we cover next? Find me on LinkedIn, drop me a note, and let's keep the conversation going. Thank you for being here. We'll see you next time on Under Review.